Hi everyone, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're going to talk about how a jury can allow for a small amount of money in a trial when the injury is really big. And when that happens, what's the recourse? And sometimes a plaintiff can then appeal or file a motion and get the amounts increased as well, despite what the jury does. So here's a case out of Suffolk County, which is out in Long Island on the East End, including like Montauk, the Hamptons, Riverhead. So what happened here was there was a simple car crash, and the jury found that the plaintiff, the person suing, was 25% at fault, but the defendant was 75% at fault. And then they heard all of the plaintiff's damages. And the plaintiff actually underwent open reduction internal fixation surgery to repair both metacarpals because he had a comminuted, that means it's broken into pieces, intra-articular fracture of the third and fourth metacarpals of his dominant right hand. So it was a pretty serious injury. And then he had this open reduction internal fixation surgery, right, to repair both metacarpals, which included placement of bone cement plates and screws. And he presented evidence, including expert medical testimony, that he experienced continued pain and limitations after a period of 10 years. And he also had more than 200 sessions of rehabilitation and physical therapy. And the plaintiff did not have full grip strength or range of motion, and the plaintiff was unable to fully close his fist or do anything that required putting his hand completely flat. Like he couldn't put his hand flat at all, such as pushing a door open. And the plaintiff's medical expert and the defendant's medical expert disagreed as to the long-term consequences, but both experts acknowledged the potential for the plaintiff to develop post-traumatic arthritis. So following the trial on damages, the jury allowed for damages to the plaintiff in the principal sum of, it was only $24,167 for past pain and suffering, and $32,000 for future pain and suffering for 40 years, and they gave him $13,600 in lost wages. So the plaintiff moved pursuant to the CPLR, that's the Civil Practice Law and Rules 4404A, to set aside the verdict awarding him damages in this amount, as inadequate and contrary to the weight of the evidence, and asking for a new trial on damages. And in an order, the Supreme Court denied the motion. So thereafter, the court entered a judgment in favor of the plaintiff against the defendant in that total amount of like $55,000, whatever the jury gave. So then the plaintiff appealed from that order and that judgment. And then the appellate division, the appeals court, just came down this week, March 11th, and they said, look, the law is that a jury verdict on the issue of damages may be set aside as contrary to the weight of the evidence only if the evidence on that issue is so preponderated in favor of the movement that jury could not have reached its determination on any fair interpretation of the evidence. And while the amount of damages to be awarded for personal injuries is a question for the jury, and the jury's determination is entitled to great deference and respect, it may be set aside if the award deviates materially from what would be reasonable compensation. And the reasonableness of compensation must be measured against relevant precedent of comparable cases, like past cases, right? And then consideration should also be given to other factors, including the nature and the extent of the injuries. And they say under the circumstances of this case, the jury's award for past and future pain and suffering was inadequate to the extent indicated. And however, contrary to the plaintiff's argument, the award of damages for lost wages, they said was reasonable, I guess, because there was a fair interpretation of the evidence. And so what they did was they said that you have to increase the amount to $100,000, and the award of damages for future pain and suffering has to be increased to $50,000. So past is 100, future is 50. So the total would be 150 instead of the total being, I think it was 55. So they increased it, not too much, but it's still surprising, right? Because a case like that, I mean, even in a tough venue, if you pick the right jury, if you really do a good voir dire and you ask, hey, can you be fair? If the evidence and the law justify an amount for millions of dollars, can you allow for that? I don't think the lawyer asked that kind of question, right? Because he just picked jurors. It's a conservative venue, sure, but if you just pick jurors and ask, can you be fair? People say, they don't know what that means. Yeah, I could be fair. I'll give you 20K on like a major fracture with 200 visits. I don't know, that's not a very good result. And actually, looking at the attorneys, it seems like it was a defense attorney that represented the plaintiff in this case. Maybe sometimes a defense attorney, for whatever reason, has like a case where a plaintiff, maybe a friend, family member, whatever, gives them a case, and the defense attorney, who usually defends cases, right, works for the insurance company, represented the plaintiff in this case, and that didn't lead to a very good result. So, but that's just the law on how to change. And it could go the other way too, right? If they give you a big amount, like 20 million, well, then they could say, the other side could say, hey, wait a minute, that's not fair and reasonable, knock it down. But here it's an example of when they give you a little bit, and then you could actually increase the amount. So I hope this was helpful. Let us know what questions you have. We are here for you. Okay, everyone, have a great day.